24th April. 24th April 2025.
I'm deeply obliged.
Can it be before? Not possible, madam. Because part that matter, madam. Otherwise,
No, because there's a due holidays.
prior to holidays,
There's a disruption in the bench.
madam. How like?
Item 2 for admission.
Do you have information?
Yes, Lordship. As
Anti
per
match?
Lordship order, medical board was constituted and we have received the report.
Yes.
মোৰ অফাৰিং লেটাৰখন আছে বাৰু।
Mr. Nath, in view of the in view of the continued mental retardedness, I think it would be appropriate to first give a interim compensation. And then, because it will be the district administration and the social welfare department to devise a manner whether they can give some semi-skilled work to this person or not, because private employment is out of question. So therefore, it is only for the state to find out whether this person can be accommodated in some sort of service. So for the time being, we propose that at least 2 lakh rupees be deposited by the state to the victim. By opening a bank account if he does not have any. After that, 1 lakh rupees may be kept in a fixed deposit. Then, because this is something which the state will have to find out how to accommodate this person in view of the report.
Lordship. Well, they have advised that he can apply for UDID to avail government services. But what is the scope and how it is being implemented in the state?
No, because we don't know about these
I
things.
have to take
Because
this.
this will only the state administration who will know about
Lordship,
it.
Lordship, Lordship. I have
And
to-
we don't know whether he is in the capacity to apply. So he will need some assistance. If required, we can get the assistance of District Legal Services Authority.
Yes,
But,
that will be better. That will be good.
But you'll have to tell us, we do how to go about.
Well, give me some time. Well, I have to get the instruction how it is being implemented.
Okay.
I'll get the information.
Because you see, otherwise, if we pass orders on judicial side,
Lordship.
then what happens is that you'll have to comply with it. But if the state of its own can devise a manner
Lordship.
so that the issue can be
Sorted out. Lordship.
sorted out.
Lordship. Lordship. Well, if it is already there, something is in place, Malad. I'll get the information and I'll place it before your lordship.
And we also record in the order that for the time being, we are proposing a compensation of rupees 2 lakh, which will we're just giving you information that this is what we are indicating, so that the state can take a conscious decision.
Lordship. Lordship. Or can I prefer taking up the matter next week so that I can come up with the instructions, whatever is available. If something already is available, because
No, that's why we are giving you time, but we are just wanting to pen it down in the order because we don't know. Memory is very short. So we just
if the what I am thinking, if lordship is indicating that compensation of 2 lakh rupees is given, then one issue is coming in my mind. But they have alleged that because of police action, he has received some injury, and this is the outcome of that injury. So the compensation will be paid by whom? That is the thing comes.
we are not ordering it. We're just giving you an advance, what you call, advance call that this is what we are proposing. So that the district administration can, in the meantime, take a call.
The home department, or if something is available with the social welfare department for this category of person.
No, because the deputy commissioner also has funds for purpose of rehabilitation. Social welfare department also has it.
That's true. Here, one difficulty I may face, because the social welfare is not a party here. I have to take it up with them. The social, this is here, Malab. This is here. This is direct.
Why?
Village scheme of থাকে সেগুলো আমরা নয়তো মাতলে যদি স্কিম আছে দিব পাৰি এনেকুৱা নাম নহয় তেতিয়াহ'লে দিব লাগিব তেতিয়াহ'লে পুলিচে দিব
Mr. Nath, you see, since we are not ordering you to pay anything, we are just expressing our view that this is what we propose. And therefore, it's just like a notice to the state government that this is what will be the next order. There's a reason for it. Number one, if an alternative, what you call, employment can be generated for the petitioner, then we can revisit that quantum of compensation if he's otherwise assured. Otherwise, police action is there. We'd have to just arrive at a finding as to what might have happened, or order a judicial inquiry. And otherwise also, because of the victim compensation scheme you have for the police compensation, we can just award some compensation. And whether the social welfare department is a party or not really doesn't matter, because we'll give a direction to the state to make the payment. And we always can devise a means that the government in its own wisdom can make an inquiry to pinpoint as to who is the culprit and then realize it from them if so advised.
True.
But we are not passing an order of compensation right now.
Lordship. Lordship may kindly indicate in the order, subject to availability of the scheme and all. Lordship will revisit it in the next day.
Yes.
Lordship.
But Mr. J. Kalita, and counsel for the petitioner, also heard Mr. D. Nath, and senior government advocate for the state, Mrs. S. Sharma, Leonard, standing counsel for the health department,
Respondent 8.
respondent number 8, as well as Mr. P. Rahman, Leonard, counsel for respondent number 7. Next one. Pursuant to order dated 4/3/2025, the Leonard standing counsel for the health and family welfare department has produced a copy of written instructions dated 20 March 2025, along with medical board report of Sri Chandicharan Ray, on a perusal of the said medical report, it appears that the victim at present has no major neurological deficits. However, his Weisland social maturity scale within bracket VSMS bracket close score was 58.3, which is suggestive of inverted commas mild mental retardation inverted comma closed.
Lordship, can I just take a short leave? Just
Yes, please.
Lordship.
So as per the said report, the victim has the potential and capability for unskilled or semi-skilled work. And it was suggested that he may be put in such semi-skilled or unskilled vocation oblique job for rehabilitation. Most of the victim was provided with the psychometric certificate. You'd find it here, in this report. Within bracket, IQ assessment, and has been advised to apply for UDID to avail government service. Please give a, Mr. Sharma, kindly give a copy to him also of this. Next, a copy of the said forwarding letter as well as the report be furnished to the, has been furnished to the learned counsel for the petitioner. Next para.
Next page.
Next para. At this stage, we request the learned senior government advocate to bring this issue to the notice of the concerned officials of the concerned competent officials of the state government, which may include the Home Department, Social Welfare Department, and or any other appropriate authority to explore the possibility of rehabilitation of the victims, Sri Chandicharan Ray, in an appropriate manner. In accordance with his IQ assessment. Full stop. In the event the said victim is needs any assistance from he may approach the District Legal Services Authority. This is of which place? He is resident of Bongaigaon. Bongaigaon. Just to enable him to make an application for being granted a UDID so as to avail government service. Next paragraph. In next paragraph, in view of the mild mental retardancy, as assessed by the medical board. We think that the petitioner would be entitled to certain compensation, monetary compensation, as an interim measure, to assist him to tide over in these difficult times. At this stage, we hope and trust that the state government authorities come of their own, may come forward with a proposal to give interim monetary compensation to the petitioner for her son, to the extent interim interim to the extent of rupees 2 lakh for the time being. First of however, it would be for the state to take a first call, and thereafter the appropriate orders will be passed on the next date of listing. Next para. We express our appreciation towards the Superintendent, Guwahati Medical College and Hospital for constituting a medical board to examine the condition of the petitioner. Son of the petitioner. Accordingly, the learned standing counsel for the health department may communicate, download a copy of this order to the said authority. Next para, list on, make it 22nd of April.
Lordship.
That we keep kept as part-heard matter.
You're not keeping it parted. It's very uncertain.
Sorry, Lordship, this order I will have to communicate to the,
We're just
So by
requesting
then-
you to, House Superintendent, because we are recording the appreciation towards them to have done it.
Obligation.
Because they have done it in a time-bound manner,
Yes, of course.
for which I think we should express our appreciation.
Item 3 for admission.
But since Mrs. Sharma,
yes, Lordship.
but by nature I am miser, so that I have not recorded appreciation for you.
Good aid, Lordship. Oblige.
This case record was called for. Record was online. Huh? तो आप लोग भी करेंगे। Yes, I'm not getting Record was called for. My friend has collected the relevant part. It goes to show that notice could not be served. my lord. He could not be trace out and could not be served. That is the
You've seen
report,
that?
my lord.
Yes, Lord.
You can set it aside, you can send it back.
Lordship, Lordship.
No, it's okay, we take it from you.
Lordship. Lordship, Petrol.
I must have given my.
Not totally.
So once you said it, we
Yes,
don't
yes,
doubt it.
Lordship.
So 6.3F was not complied with.
Yes, Lord.
Mr. A.S. is there and counsel for the petitioner. Also, all the respondents are there. Your name?
I'm Kalita on behalf of people.
I'm Kalita on behalf of Ms. P. Barua, standing counsel for ECI. Next para. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the ex parte opinion dated page 14. So 1/8/2023 passed by so and so and so and so. Thereby declaring the petitioner to be a foreigner. Next para. Pursuant to order dated 10/2/2025 and 24/2/2025, the learned standing counsel for the FT matters has procured the relevant records from the concerned tribunal, and the same is placed for before the court for its perusal. Next, on examination of the records of the tribunal, it appears that the notice issued upon the petitioner by the learned Foreigners Tribunal, 3rd, Borpeta, was not served upon the petitioner in accordance with P5F
Yep.
of the foreigners within bracket tribunals, bracket close order, 1964. As per next para, as per the process service report, as the petitioner could not be found in the village, the notice could not be served and the same was returned. Next, the requirement of section 3(5)(f) of the foreigners within bracket tribunals, bracket close order, 1964 is as follows. Quote that. Next, accordingly, as the notice was not properly served on the petition in accordance with law. The court is inclined to hold that the impugned opinion dated 1/8/2023 asked by the learned member for Foreigners Tribunal at Borpeta is initiated because of non-service of notice. So accordingly, the said opinion dated 1/8/2023 asked by so and so and so and so is hereby set aside. Next, the matter is remanded back to the said learned tribunal for giving an opportunity to the petitioner to file his written statement with along with documents. And thereafter to file. Thereafter, an opportunity should be given to the petitioner to lead evidence and the matter be decided in accordance with law. Next paragraph. The petitioner, who is duly represented, the petitioner namely so and so, who is duly represented by his learned counsel, is directed to appear before the Foreigners Tribunal 3rd Borpeta within 30 days from the date of the order, without any requirement for issuance of any notice to appear. And by producing a certified copy of this order, the petitioner shall await for further directions from the said learned tribunal. Next paragraph. It is provided that in the event the petitioner does not appear before the learned tribunal within the time allowed, it will be open to the learned tribunal to treat the petitioner as absent on call and pass a fresh ex parte opinion in accordance with law. Next, the records are returned to the learned standing counsel for the FT matters for return for its return back to the concerned tribunal.
30 days. 30 days.
30 days.
30 days time to
Fine,
appear without
fine.
notice. Petition stands allowed to
Fine.
the extent is indicated.
Deeply.
Supplementary items 16, 17, and 18 for admission.
Yes. Mr. Chaudhary, you've seen that?
My lord. That
You
affidavit
have
that was
specific
filed.
instructions.
Yes, my lord, we don't have anything to reply, my lord, in writing. Your lordship may, my lord, continue with the.
Well, yesterday one affidavit filed by Mr. Datta's Junior. I think it is not in the.
My lord, I have got strong objections to my lord filing of additional affidavit when the matter has been heard for a very long time, my lord. And that too without leave of the court. How can they keep on filing, my lord, affidavits? What is the purpose, my lord?
Look,
right.
Your lordship has been
Once
very
we start
kind, my
hearing-
lord. Your lordship has been
purpose
very
is
kind
very
to hear
simple.
it.
I take it as an offense.
Yes.
Well,
I
the
have taken
question
the
is-
offense.
No, we
I
can't
take
Your
the
permit that.
lordship
offense.
kindly see one thing.
We can't permit that. Once
no,
the hearing is
that's
But
started.
if they can take the, my lord, plea, not taken in the writ petition and not taken in the appeal also.
What plea?
And we are,
lord, we are
we are
going
hearing
on
for
issue,
last.
my
No,
lord.
the matter has been hard for 4 days,
Yes,
my lord.
then-
Your lordship has been
then we'll
very
not-
kind to give a patient hearing. Then they file an additional affidavit, my lord.
Because
Petrol
you are
also-
submitting your own
and that too
documents.
without, my lord, leave of the court.
Without leave, you
This
can't
is
file.
not permissible, my lord.
My lord,
Without leave, you can't
my lord,
file.
your lordship kindly hear one thing.
Uh-huh.
Now, the question is this, the law is very explicit in this line. Now, the question is, you never took that point in the read code before the read appellate code.
No, you see
You
that,
file an affidavit all of a sudden.
No, we did
Taking
not
that-
file an affidavit all on a sudden. There was a direction of
I
this,
don't know
of
what
this
sort
court,
of
my lord.
submission.
He must
make.
know.
you look
He
at
was
the
there
order-
all through.
you look at the order sheet.
It is in the order, my lord.
My lord, the simple thing is this, when the plea was never taken,
No, but then we
now
release it
can
from
it
part
be
head.
supplemented by the
We
affidavit?
release it from part head. We
Yes,
can't
my lord,
keep on
I
hearing
think
the
about
matter and then have
1978
affidavits.
Supreme Court is very clear on that line. My lord, I
Okay,
need not
you-
elaborate all
you
that.
Have a fresh argument because we will not keep it part
My
head.
lord, that
My
is
lord,
the,
your
my lord,
lordship
they will
kindly,
succeed in
kindly
their purpose,
visualize,
my lord. They
your
will
lordship
succeed
kindly
in their
visualize
purpose.
one thing. You never say something in the read code. Now, we
No,
did
that-
not have any chance to rebut that. Now, you,
But
in the read appellate code,
course
you
of
do not
hearing-
have that plea also.
Mr. Datta will reject that.
That's a
additional
different
affidavit-
thing altogether, my lord. If your
can't
lordship
have it.
reject, but for the
In
sake
course
of
of-
adjudicating the matter in a correct position,
No, you can
My
have an objection that these are out of pleadings. But to file an affidavit is,
no, that's I leave up to your lordships, my lord. Because
No,
we have
not-
filed, because there is no other way. Because the
Without leave,
question
we will
is,
not
if you
accept.
say,
It's their own document, my lord. They have supplied, so we
without
got it
leave,
and
we will
we'll
not
file
accept.
it.
Without leave, we will not
otherwise,
accept.
my lord, it is incumbent upon all of us to say that where is the original record of whether your lordship, if your lordship sees the AIIFR.
My lord,
Give
your
me
lordship
that.
will look into
Well,
another
your lordship
aspect.
kindly say earlier affidavit.
Another aspect, my lord, the affidavit that was filed by them yesterday, that is not on record. They could have
All the time
mentioned-
they do all that
They
thing.
could have, my lord,
We
mentioned,
serve
make
to them,
make
they
a
say we
mention.
did not receive.
that issue
What
be-
is this? The last occasion also they did the same
Either
thing.
their color.
Today also.
No,
they-
no,
they are saying
I
the
don't
same
say
thing.
I am not received. What I say is that you have filed an affidavit yesterday.
No, what
You
all
could have
this hide
mentioned
and
before
seek?
the court that it should be brought on record. That mention also they do not make. What is the purpose? That is why I am asking, my lord. Let him take
Purpose
offense.
you know
I
better
am
than
taking
us.
offense.
Purpose
Because, my
you know
lord,
better than us.
oh yes, I
What
know
is your
better.
purpose
We know
to
better.
file an affidavit here? Why this hide and seek game, my lord?
Where is the hide and seek?
They
The
are
court directed to
corporation.
file us an affidavit. We have filed the
They are
affidavit.
corporation.
You may not interact with each other. Once you have addressed the court, that's good enough.
My lord, your lordship kindly see for a while the additional affidavit filed by us on 10/3/2025. This is WA 215 of 2024. They must answer it, my lord, in order to
242.
page 242. Now, my submission will be only this much, that when you are saying something by you of an affidavit, my lord, those facts, my lord, we must have a chance to say all that.
Now, in what stage, my lord, they filed this affidavit? My lord, they filed an affidavit. Where is that? I think in the writ appeal, they have an. My lord, I'm just taking to your lordship for that. That is, your lordship will find the, please, come on. This one, no? Where is the statement? Here. My lord, your lordship may come at page 174. 242, writ appeal 242. Paragraph 3, your lordship, can this at page 173.
It was filed on 27/1/2025. After that, a reply was filed on 20 February 2015. And then the hearing started. We heard the matter on 20 February. After that, it came to this bench. We heard the matter on 25/2, on 6/3, and 24/3.
The question, my lord, I am conscious of what your lordship is trying to mean. But the question would be, when you are making such sort of allegation, is it not your duty to produce the record before the court to persuade your lordship to see what is what? And therefore, my lord, I requested your lordship to see at page 242, paragraph 5,
Mr. Datta,
whether they have complied all these things.
but Mr. Datta, then you should have not started the argument.
My lord, should it not be our endeavor to persuade your lordship?
No,
See,
but now
here
you
is the
see,
case.
at the fag end of the argument, now you're saying that the records ought to have been produced. Then why we are spending time?
My lord, when I argued, my lord, I made a request to your lordships also. It is their burden to prove it.
It's
Now,
okay
where is
if
the
they-
materials
no,
before your
if they
lordship?
fail, why you are interested in having those records and
That is because it is a non-issue, my lord. It's not an issue at all.
that's
It was
that's a-
never
that's a
canvassed
course
before
of-
the either before the read court
no, that's
or
the
before
subject
your
matter of
lordships.
argument. For that, you can't supplement it by affidavits without leave of the court.
No, they have trying to improve their case by filing this affidavit. What they are saying that the school was never taken up there in demerger
You
proceeding.
see, whatever plea is taken has been taken. After that, hearing started.
Now your
After
lordship
starting
has
of
to
the
see.
hearing, in a parted matter, we can't allow you to bring pleadings like that.
My lord, the only thing your lordship is required to see whether it is correct fact, whether they are trying to expose. Now, what is the material before lordship? No record has been placed before
That's
lordship.
okay. You see, you
And
build
it
up
is
your-
not a, my lord, they have said it's
Mr.
a
Datta,
seat
for that
unit.
you will build up your argument. For that, we don't adjourn the matter to get the records after the hearing has started. The requirement of
It is for to find out the truthness only, my lord, nothing else.
this
Because-
is a intra-court appeal. We are not hearing an original matter.
That's the reason, my lord, intercourt appeal, but then that issue was not there at all before the read court.
Let you hash it out in the argument.
No, that's
But
the
for
reason,
that-
my lord, I am saying this
for
is
that
the least what we
can't-
can do. My lord, if your lordship refuses to
We
file
can't
our
accept-
affidavit explaining all these things and ask them to produce the record and show, otherwise what happened, my lord, 242 page 5, your lordship, kindly see for a while. as the net worth of BVFCL
just nothing,
after
sir.
restructuring,
Just
restructuring,
nothing, sir.
here na.
Affidavits we can't accept.
No, no, your lordship can only see this. It's not a question. It's not a first time. It came earlier also. What the report of the AIFR, that is I am highlighting. The
No,
net
Mr.
worth,
Datta, we are not interested.
no, no, Melody, your lordship kindly see what this AIFR has said.
I am not spending 1 minute of my judicial time in hearing these things unless you start your argument on merit.
My lord,
not
merit,
spending a
merit we
single
have
moment.
argued. So far, this position is concerned, while I argued before your lordships, I requested your lordship to explain them how the school authority was never taken by this organization. And it's not a Sikh unit, admittedly. It's not a Sikh unit, they are saying Sikh unit. Now, I filed an application to book them under section 209 of the CRPC because of making false statement before the court. Now, these are very vital issues, my lord. And when the facts are like these, my lord, we shall not give up, we shall go up to the last.
No, definitely, you have all the right. So let
Therefore,
me-
my lord, when here is a case where in the read court, these things were not there, we did not have any chance to rebut. You file and read
you should
appeal.
not have started the argument.
No, no,
Once
no.
we have a
No,
partner.
no, when even in the read appellate forum, your lordship kindly say, have they taken that point? It was given a go
If it is not there, it is not there. That's a issue of argument.
Then, my lord, your lordship, hearing this issue, which I will say it's a non-issue totally. Then if it is your
Mr.
lordship
Datta,
hear it,
Mr. Datta, let me tell you very frankly, number one, at times we are more prepared than the lawyers when we hear the matter. If we take a plea that we'll hear only X and not Y, it will be a bad day for the bar. I can assure you, I can dispose of 100 matters a day, but it will be a very sad day for the bar if I start disposing of matters on the basis of what I have read and what I have understood.
my lord,
As I come from the bar, I give all opportunity to everyone to make a submission. But
now,
that does not mean that if I am hearing you, I will just make a pigeonhole and say that this is not argued, this is not before the single judge, this is not before the this is not pleaded, this is not there. Then it will be a sad day for the bar. I can change my mode of conducting court right now.
my lord, I'm not on those things at all.
So therefore,
my-
I can assure you, in 80% of the cases, I will be more prepared than you.
No, that I understand, my lord. I have seen
And
your
therefore,
lordship.
if I stop the opportunity of a lawyer to make an argument, this bar will not grow.
That's true,
They'll
my
all be
lord.
afraid of entering into the courtroom for 6, just because the court has taken over the entire what you call argument.
My lord, so far, my experience before this honorable court, I can say this court is one of the best court,
No, I won't say that.
No,
I
no,
won't go to the
whether-
extent.
whether
But
it
I
is
have-
junior lawyer,
I
whether
have,
it is
I have
senior
come from the
lawyer.
bar, and I think that I should give an opportunity of everyone to
No,
make the
that's I have
presentation.
seen, my lord, because
But that doesn't mean
irrespective,
that pleadings would come when we are in the midst of a parted matter.
no,
that
but
without
then,
leave of the
but
court.
at the same time, your lordship see under what circumstances were in this position.
No,
Because
whatever
you say
you see,
something,
you have, Mr. Datta, you are more seasoned than me. You and Mr. Sharma has dealt with more litigations than I have handled in this bench. You know how to deal with those issues.
no, my lord, we
But
respectfully
if-
agree what your lordship
But if
saying.
pleadings come and multiply, then we can't keep it parted.
But then these issues.
Can you
But-
tell me under which? Can you tell me under which canons of law can I keep a matter parted and then
No,
bring on?
regarding parted, my lord, I have no issue on that. But only question is, my lord, when you are taking up certain point by filing an affidavit at the fag end, my lord, equally we have a right to make a prayer before this honorable
You
court.
could have made it then.
It is
And
definitely,
before we start the argument.
but
but
have
after
they
the-
satisfied your lordships, my lord?
After argument, we will not accept, after
My lord,
having
it
it
is
parted for
still
3
what-
days.
Why I understand, my lord, still open for the sake of adjudication in precise manner.
No. Not without
Otherwise,
leave.
what will happen, my lord?
Not without leave.
The
That will
issue
not
which was
entertain.
taken up is a totally a false statement before this honorable court.
That will
and
deal
they-
with it.
And
is it-
therefore, my lord,
No, no, in the country, is this the first case where false allegations are made?
it is rampantly, it has been going on.
So therefore, you see, it's not a first case where for the first time
But,
in a writ
my
court.
experience is very bitter.
No, we understand, but Mr. Datta, if it is not for the first time in the country that a false statement is made somewhere, what is the point in having an argument started and then have exchanged the pleadings?
No, my lord, I argued it in terms of the affidavit filed by them.
We will
And
take it. We are still
even-
prepared to
And
take
therefore,
the hearing.
we did not have any chance to give any rebuttal.
Hmm.
Now, therefore, these are the papers we are submitting in order to adjudicate the matter in a precise manner. Otherwise, my lord, your lordship will not come to know what had happened actually.
Why would we hear it then? Why would we spend 3 days time?
My lord,
And
if,
even today we are spending time.
if
No,
your
we
lordship
close this
has
matter.
given 3 days, your lordship can give us one more day. Because after all, my lord, my clients, they should not suffer for all these statements, which has been made quite unnecessarily. And it's an, I'll say, my lord, it's a
Mr.
totally
MP
a
Chaudhary,
non-issue.
Learned Senior Counsel for the appellate is present. Next, Mr. Who has filed an affidavit? You have filed an
Well, I
affidavit.
filed in.
So what is jointly filed, my lord?
In,
Where we have, my lord,
in
this
connection
affidavit
with,
filed just to assist your lordship to come to the conclusion that the industry was never seek, my lord, as per the IFR order
that's
dated
okay.
2002.
Uh,
That I have read it. That is just assist your lordships to arrive at a right conclusion, correct conclusion. So, my lord,
Our High Court rule says that once an affidavit is filed, the other side would have an opportunity of rebuttal. That is what our High Court rules say. If you file an affidavit before 24 hours, it will not be taken up for consideration.
my lord, if they, my lord, if they do not
No, no,
expose,
we are, you see, I'll tell you, this is the High Court rules.
yes,
High Court rules prescribe that the affidavit filed, one must get an opportunity of rebuttal,
yes.
number one. Then why you are hearing it in part? Second is, affidavit which is filed before 24 hours of its, within 24 hours of filing, cannot be taken up by the court for hearing.
My lord, since we are in the midst of hearing the
Then you
case,
can't use, you
Because-
change the, you
no,
see,
what
then
we are
you,
doing,
then
my
you
lord?
challenge the High Court rules.
No, there is no question. Just this affidavit
Yeah, I
does not
can't
say
keep it
anything
parted. No, no.
except
I can't-
citation of
I
decision.
can't keep it parted, no.
Hello?
I will not keep it parted when the pleadings are being exchanged. Either I dismiss your, reject your affidavit, or we don't keep it parted.
I think Pater not asking. Lordship, whether it is kept Pater. I think so far I know my it is not Pater also.
Okay, we will clarify it. Mr. As the Learned Senior Counsel for the private respondent in WA 242 of 2024 has submitted that an affidavit has been filed by the private respondents which is not on record.
The earlier one is there, man. Earlier
Mhm.
one is there. Island 10-3 is there.
Next paragraph. On a query of the court, it has been submitted that in connection with WA 242 of 2024, an additional affidavit was filed by the petitioner on 27/1/20, by the appellant on 27/1/2025. And therefore, the affidavit, so filed on, when it was filed? Yesterday. On 26/3/2025 was to controvert the stand taken in the said additional affidavit. Next paragraph. The records show, the records of WA 242 of 2024 show that the said additional affidavit was filed on 27/1/2025. And Thereafter, the analogous hearing of
We filed a reply to that.
WA yes, before that, a reply to that affidavit was filed on 20 February 2015, as of 25. So thereafter, hearing of all these three writ appeals had commenced from 25 to 2025, and the submissions remained inconclusive. So the matter was again heard in part on 6/3/2025, and as the hearing could not conclude, the matter was again heard in part on 24/3/2025. First of, in course of next para, in course of hearing on 24/3/2025, it was brought to the notice of the court that in connection with WA 215 of 2024, an affidavit was filed
On 10/3.
on by the respondent number one in respondent number one therein on 10/3/2025. Accordingly, in order to enable the learned senior counsel for the appellant to obtain instructions, the matter was adjourned. Next para. Today it has been, today the court is informed that on 26/2/2025, another affidavit has been filed by respondent number one, a private respondent. As the said affidavit has been filed without leave of the court, and in course of the hearing of the parted matter, the said affidavit is, though not on record, is outrightly rejected. Full stop. The matter would be taken up for hearing at 2 p.m. I'm a bit disturbed. I don't want to start the hearing right now. At 2 o'clock, we'll commence the hearing.
Your lordship can fix some other. Because, my lord,
No, because again, it will go to for 3 weeks. There's a disruption of bench in the next week.
After Bihu. After Bihu. Going to Shillong.
Your lordship has given so much of
Because
still time.
He is also leaving for Shillong, my lord, right now. So
Okay.
any other
Next,
day, my lord.
on request made by the senior counsel for the private respondents in these three writ appeals, the matter stands adjourned today. Next matter is the next hearing can only be held after the vacations. The court is not inclined to keep the matter as parted. So
Your
accordingly,
lordship has
matter is
always
since
spent
released
so
from
much of-
parted. No, the bench will be after Bihu also, the same bench will be there, but I can't keep it parted. We are bound by the rules. We can't do anything.
Your
It's 2
lordship-
weeks, there'll be disruptions in the bench. You can't avoid it.
A date may can be fixed
Uh,
after 3 weeks.
24th April, my lord.
Okay, 24 April.
Oblige.
Oblige.
Early August.
Upgraded item 13.
Now your lordship is looking very handsome.
Pardon me?
With these goggles, your lordship is, when I entered the court, man, I could not catch your lordship, whether you are same judge or somebody else.
No. Mr. Sharma, I am growing old. So the first footstep of growing old is cataract. I had a cataract operation. So now I'm certified to be old.
Cataract, my lord, is not, that does indicate that your lordship work. Your lordship doesn't look like so.
I don't know. That's why
Anyway,
it's the first sign of growing old. I'm still in that what you call I'm still in that lean period where I have to avoid light. So I have to wear a
your lordship has not reached the retirement age. I am 70. Still, I do not use so much of goggles. Only one reading glass.
Well,
The
yes,
eyes are
yeah. God has blessed you with
Thank you.
uh,
Of
with,
life.
with these virtues. Okay, next.
Upgraded item 13, WP Criminal 26/2022.
Okay. Yes, sir.
May I please your lordship?
Yes.
Matter may be passed over for the time being.
কল করেছিল একটু চাই আছে নাকি একো নাই তুমি চিন্তা করো নালাগে ইনকোয়ারি রিপোর্ট ওয়াজ কল করা
Okay, we'll take it up after some time.
Yes, Lord.
Then.
ইনকোয়ারি কল করেছিল তোমার একো নাই এসপিল করা আচ্ছা আইছে দেখাইছে না আমাদের
Item 4 for orders.
My lord, kindly pass on for the timing, lordship. My senior is another board, lordship.
It's a review petition.
Yes, lordship.
Okay, after some time.
Hello.
Item 5 for hearing.
Mr. Sharma, you've seen the record?
Lordship, I have not seen lordship.
Right. Yes, Mr. Talukdar. Which page is the opinion?
Opinion is page, my lord, operative part is, my lord, page 62.
Page number
62, my lord.
62. It starts from 54.
It starts from 58, my lord.
Oh, 58.
Yes, my lord.
Mr. Sharma, just give the record for once.
Yes. My lord, the opinion is given that the present petitioner entered India after 25/3/71. My lord, the petitioner already filed his written statement before the learned tribunal, my lord. The written statement of the petitioner is page 13, my lord. My lord, evidence part is, my lord, page 16. Yes,
In your evidence, you have destroyed your case.
page 16, my lord. Exhibit A is the voter list certified copy of 1965, my lord.
Correct.
My lord, para 4, my lord, that after on the year of 1965, my father has shifted at village Tekagao, Muza, so and so, district of Assam. Hence, my father's name is dropped from the voter list of Balu Bari Pator on the year of 1970 due to shifting, but unfortunately could not appear in the voter list Tekagao in the year of 1970. Now, that after from the para 5, my lord, that after my birth on the year of 1980, my father was expired at village so and so. 6, my brother Kudus Ali and Kamal Ali's name appeared in the voter list of 97, serial number so and so, my lord, in the district of Borpeta, Assam. Now, my lords, Exhibit B is the voter list of 1997. So I am going to establish that my father, my lord, kindly have a look of page 1965 voter list. 1965 voter list, my lord, page, my lord, translated copy, page 32.
Your family is not there in the common voter list. In any of the common voter list, your family is not there, number one. Number two, before the, uh, before the Gambura, you produce a Kabinama,
Yes.
and in the court you have not produced that. So therefore, the entry in the Gambura certificate would be a secondary evidence. It is otherwise impermissible.
My lord,
It is for those people who don't have an evidence and they bring a linked document. But you produce a linked document before the Gambura, but you fail to produce it before the court.
My lord, petitioner already produced the document. Kindly have a look of page 17, my lord.
It's 17 years.
Wait, my lord, the exhibit to B is the voter list of 1997, my lord. Exhibit is the electoral photo identity card, my
So
lord.
then you are missing out on what I am saying.
Yes.
The court query is that before the Gambura, you produce a Kabinnama.
Now, my lord, linkage certificate already established, exhibit F, my lord.
That's what we are asking you.
Yes, my lord.
Which is the primary evidence, Kabinnama or the Gambura certificate, which
lord,
according to you is the primary evidence.
Right, Kabinama will be the primary.
So
evidence.
primary evidence was not produced before the tribunal,
It was not produced before the time.
but
tribunal, my lord.
you produce it before the Gambura.
Later on, my lord, it was came to know by the petitioner that Kabinama is required, my lord. That is why the same was not produced. But it was produced before the Honorable High Court, my lord.
No, we don't examine original documents. And the Gambura says he doesn't know when you got married. He has the copy of Kabinnama and doesn't know when you got married. He says that your brother came and he gave a certificate.
Yes. Gambura's statement is, my lord, page 29, my lord.
Yes, we have read that.
Yes. Apart from this, my lord, this petitioner's own mother is declared as a citizen, my lord, by the tribunal, my lord.
Yes. Which page?
Page 54, my lord.
54.
Yes, my lord. Banu.
It was never mentioned before the tribunal.
Is already disposed.
You have to mention before the tribunal.
That time it was not.
When, according to that opinion,
Yes,
at page 54,
yes.
when did your parents got married? What is the date on which they got married?
My lord. This was not there, my lord.
It was not there. Now this, on the date 11/1/16, when the opinion was rendered, what was the age of your mother?
There, my lord. That petition was not with me, only the judgment has been given to me, my lord.
Okay. In- Does the name of your grandfather match in the compared to the proceedings of your mother at page 54
Yes, my lord.
and the present opinion? Does the name of your grandfather match?
Yes, my lord. My grandfather name is, my lord. My name is
Sadar Mullah.
Adar Mullah.
That's why we are asking. Our question is
Yes,
in page 54 opinion.
yes, my lord.
Is the grandfather's name same?
My lord. It will be same, my lord. It will be same. But it is not mentioned, my lord, so far as this.
Please come to page 54. Turn over to page 55.
Yes, my lord.
Come to paragraph 6.
My lord, I have carefully perused the evidence as well as the documents submitted exhibit by the opposite party. It appears the opposite party, Khat Banu Nessa, was born and brought up in village so and so, but and got married with one Abbas Ali. That is my father.
Son of
Abbas Ali, my lord, son of late Razob Ali
correct.
of village Sekhargaon.
Correct.
Yes, my lord,
That's why in the last case we were saying that we were more prepared than you.
my lord, Khat Banu Nessa was born and brought up in village. Khat Banu.
No, we understand.
Yes, his
But your-
grandmother.
But your husband's father's name is different in 1965 voter list. Now you have produced with the evidence of your mother in her case when he says he married who, that she married whom?
With one Abbas Ali, my lord.
Son of Raja Ali here.
Son
Abbas
of-
Ali, son of Sadar
Son
Mullah.
of Razob Ali.
Correct.
Hmm.
Nothing to, no requirement for any further hearing.
My lord, let me go.
We told you some time ago in the last matter we said
My,
we'll be more prepared. If we are more prepared, then it will be a bad day for the bar.
no, my lord, must
Then
not.
we don't need a hearing. We don't need your assistance now.
Let a time will be when I will obtain instruction, my lord.
Mr. Talukdar,
Yes, my lord.
you see the difficulty is
Yes, my lord.
that every time the matters come to our residence, we spend our own time to read it. If this comes tomorrow again I'll have to read it. And that is why I made that statement. If I become more prepared,
Yes.
it will be a sad day for the bar. I would not hear you.
Yes.
We had no reason to hear you. We will be more prepared than you. Disposing of 100 cases is not a tough business.
My lord, let the time will begin. I will. Let the time will begin, my lord.
No, but it can't go on like that.
At least
We spend time. We can't. You can't improve it.
whatever maybe I obtain instruction, my lord. Regarding
No. You see, you already have that instructions. That instructions were available. That is why we read paragraph 6.
My lord, this is a different judgment, and my judgment is my different judgment.
No, you are now. You see, now you are changing style.
Grandfather is same.
No.
Your lordship is correct. Grandmother is saying. So at least I may be allowed to at least some time to.
Okay. Also as I represented, in course of hearing,
Yes.
with reference to the entry of the projected father of the petitioner in the electoral roll of 1965, where the name of the father of the projected father of the petitioner is Abbas Ali, and that of of her projected grandfather is Sador, Sador, Mullah, Mulla, comma, whereas in paragraph 6 of the opinion dated 11/1/2016, in FT case number, page 54, so and so, rendered by the learned member, Foreigners Tribunal 3rd Barpeta, the name of the projected grandfather of the petitioner is late Rajab Rajab Ali. Full stop. Accordingly, on the prayer made by learned counsel for the petitioner, the matter stands adjourned to enable him to obtain. Stands adjourned today. Next list after ensuing due vacation. Take a break and come back.
My lord, my other two items are there. That maybe, I mean, if your lordship kindly adjourn.
Let's just see. Let us come back.
Yeah.
নেক্সট কোনটো মাতিব দাদা? অ 13 সেইটো এপিএছচি নেকি? হা আৰু এপিএছচি টো কেতিয়া মাতিব? ছিক্সটো দিয়কচোন দাদা ৰেকৰ্ডটো। ছিক্সটোতো নামাতে এতিয়া। চাই ন 6 ফাইলটো নাই। নিলো বাপৰে নিদিলে বহুত সময় থাকিলো। মই ইফালে হাইৱে দি মাৰি দিওঁ, সোনকালে গৈ পাওঁ। তাৰপিছত আপোনাৰ 7টা মানত লৈ গৈছো, আছে 9:30 মানলৈ আছে।
According to you, is that inquiry concluded?
Malad,
Or is it going on?
the status report is in seal cover. I could not go through.
No, in field, you will have information from the
Not
field.
that. It is otherwise pending as per my information.
It's still pending. Sudaji. Mr. Nath, well, in these few days, I'm finding that old criminal habeas corpus matters are pending.
Lordship.
Can you find out the case numbers? Because we find that these are very old matters. It should
This
22
is
matters.
22.
So I think those matters can be, we'll check up and upgrade it for hearing, because keeping these matters pending for long doesn't look good.
Malad. I have, Malad, I'm appearing in some of the cases, Malad, I have the numbers. I'll just, from my office, I'll collect and
Yes.
submit the request.
Not, it's not a good state of affairs. This inquiry since 2022 is pending. And this, for petty things, the judicial inquiry could not proceed. Since 2022, either the witnesses are absent or the what you call this, the IO is absent, and there's no progress at all. We are still at the same place where we were there in 2022.
Lord, Lordship, if Lordship permits, Lordship may kindly give me a copy of the report, my lord, what is there. And the IO and all this things, my lord, I'll take care of. The IO, I'll ensure his appearance in the inquiry.
No, in fact, I forgot. It was about 4 years back. In course of a meeting held with the authorities of the Home Department, it was pointed out, I just forgot the name of the officer. He was the superintendent of police of a district. And he had prepared a hyperlink chart by virtue of which he could locate the IO of the cases, the medical officers of the cases, the official witnesses in that hyperlink chart. And so the progress of cases which he was handling was updated approach. The said superintendent of police was fully aware of what is happening in his district. We wanted to replicate it for all the districts. And then suddenly these meetings could not be held because of COVID and all, and we lost track. Last, I think he was the superintendent of police at Golaghat about 3 years back. I'm unable to track the name of the person. Whether he's in service or not, that also I forgot. I don't know. If this person can be located, he can really help the Home Department in preparing something like an app by virtue of which all the you can keep a track of the district-wise official witnesses, including IOs of the case. He had given us a presentation. It was a very fantastic presentation. It was during the tenure of Honorable Justice Chief Justice Lamba.
Okay.
During his time, he gave a presentation. But since I was no longer associated with that, I just forgot. But your officers would know. And there's another aspect of it. There are senior officers who did not like the proactive role this superintendent of police was
Taken.
had taken. And perhaps that was not encouraged at at every level of the police management and home department management. But the presentation which he gave was really fantastic. It's not, in fact, if you can have a track of this person and then introduce it, it's only a hyperlink document, not much expenditure in the Excel presentation. He just has a hyperlink and the next place of posting of the officer or the medical officer or the police personnel.
Office.
IO.
Yes.
He kept a track like that. And his performance was incidentally known to the home authorities and the police department at Nagaland. They were in touch to make certain thing, what you call the applicable in the state of Nagaland. But I'm sorry, I don't remember that name.
I'll try to find out one of them. Or if any mechanism they have put in place, I'll try to find out. But in this particular case, Malad, Lord, you may kindly give me a report, the copy of the report, Malad, and I'll ensure presence of the officers Malad, before the inquiry committee. Malad.
What was it? 1924. You just go through it, we'll give it to you.
Lord,
Dasji, make copies and give it to both Mr. Chaudhary and to Mr. Nath. No, to Mr. Nath. Mr. Chaudhary, give it to Mr. Nath. For today, it will not be of much help to you. From 22 to September 24, we are at the same stage. One thing.
in the meantime, the statement of the IOs have been taken. Only the 2 constables are left. This I will ensure, Malad. And in fact, this report is of September 2020.
Yes. It was supposed to be listed on 110.
Yes, sir.
It has been listed today.
Well, I'll get the up-to-date position, and 2 constables they have named, they were not there. Otherwise, the statement of the IO has been recorded. The official witnesses, Malad, Malad, if in the meantime they have not been statements have not been recorded, I'll ensure, Malad. they will appear immediately, on the next day.
And in these cases, has what you call the inquiry by the executive has been
Yes,
concluded?
yes, but it was done. It was done.
Do we have a copy of that?
I have.
What does it say, Mr. Nath? What does it say, the inquiry?
No, it's an encounter, my lord.
It's an encounter.
Lordship.
Mr. Nath.
My lord.
uh, This is what I was interested in. Please check up this flag.
Lordship. Diplomas. Lordship.
Mr. Nath,
My lord, my lord.
you see, we are trying to understand when this inquiry by the district administration took place. They had everything. No, not required. We don't need that.
Lordship.
You see that flag?
I have seen.
You've seen that flag? No, just open that page. Yes.
It is
Yes. In the down below, you'll find that box.
box. My lord.
The arms and ammunitions
Lordship.
which are there.
Lordship.
Now, you see, in a case of encounter, so far as I understand, number one, the case of the police is that these two people were arrested and then they were taken into in a jungle,
Lordship.
and then there was an ambush by the extremists.
My lord.
Correct. Now, how many policemen were there? We can only find out from the entry made in the GD entry made in the police station when these people went out for the went out from the police station to that round. Correct. So how many policemen are there? We can't identify right now. Number two, these arms and ammunitions were issued to these police personnel.
Lordship.
As per the issue register, what are the arms which are issued to this police personnel? Third, after this encounter, what is the loss of ammunitions from the state? And this fourth is that that this man who was these two people who were shot, from that flag page we find that they are also wearing bulletproof vests.
Bulletproof.
After that, there's an injury. Now, if there's a bulletproof injury, the fourth thing would be, where is that cartridge which hit these two people? And the entry wound and the exit wound. That you are not able to identify immediately what is the nature of the entry wound and the exit wound.
Gotcha.
The distance we can't find out from the postmortem report, that the darkness, the black carbon, I just could not read. I just flipped it and I'm returning you back. I have not read it thoroughly.
Gotcha.
But prima facie that you few pages here and there you find that postmortem report is there.
Report is here. Malad,
You please see the entry and the exit wounds. That blackening mark is not there. So therefore distance, either they are not captured that, or
But postmortem report clearly malad, indicates the injuries, malad,
yes.
the entry wound and the exit wound. It is reflected. Malad.
Look, read the description. You will not find that entry mark with the black carbon.
Malad, I am handing out the copy. I have a copy. Malad.
Okay. Because unless the army report is found, how many bullets have been consumed in that
Malad,
encounter?
during the course of hearing, malad, because all the weapons which were listed there, those are not belong to the police. Some other weapons which the extremists they had, malad, those are also there. In fact, this is the list sent for the FSL report. All the ammunitions, malad, were used by police or malad, found at that at after that, malad, the incident, those were sent for FSL report. And the entire list, Lordship has rightly indicated, malad, that
It is in this report. That's why you have this postmortem report.
Lordship.
Look at number 2 and 3. Perforated injury, entry wound is present over the right forearm,
Yeah.
so proximal in the wrist joint. The entry was circular shaped, inverted, but it doesn't say about the carbon residues.
Malad,
And then there's an you see the entry wound is present over the right forearm. Correct.
in fact, there was indiscriminate firing.
No, we understand, but
Logic,
you're just trying to find it out.
Logic.
The entry wound is over the right forearm,
Malad.
proximal to so and so in the wrist joint. Correct. So it is somewhere here, Mr. Nath.
Logic.
In the hand, it should be somewhere here during the proximal
Logic.
of the wrist joint. And the entry wound, you see, cerebral bone through the lateral aspect of the left elbow joint, making an exit wound. Right forearm exit wound.
Yeah.
That means the bullet injury would be somewhere from here and is coming out from here.
Side. From side. They were malad, inside the vehicle, police vehicle, and they were taken to a particular place with the police team. At that point of time, in the jungle, malad, there was ambush. Malad, kindly come to internal page 4 of the PM report, malad.
No, first, we're trying to analyze the entry wound and the exit wound. So
Yes.
what actually is the angle of the injury?
Well, 2 injuries were indicated in the first page of the PM report. Kindly come to page number 4, internal page.
If somebody is in the car,
Malad.
in the car, and in the car, the position would be in a sitting position as we are.
Logic.
Correct. So entry wound in the left forearm with exit wound in the back is very difficult to visualize. He's sitting on the, Mr. Talukdar is sitting on the chair. Now just visualize the entry wound and the exit wound. Because if he's in the vehicle, what vehicle we don't know.
Lordship.
It should
But
be a gypsy.
all details are there. It's a Jeep, Bolero vehicle.
It's a Bolero vehicle. So that means if in a Bolero vehicle you have gate. So sitting inside the Bolero, how much would you be exposed?
But before the report of the district magistrate, there is a report of submitted by the SP to the district magistrate asking for an inquiry. Kindly come to that, my lord.
Yes, problem. I think we'll need a forensic expert to recreate the scene.
Analyze it.
Because if you can come to this next page of what you had shown us, the postmortem report,
Lordship,
serial number 8,
my lord.
perforating injury, entry wound is present over the front chest.
Lordship,
We omit all these things, come to the fourth line.
my lord.
Left pleural, left lung exits through the posterior chest wall on the right side, 10 centimeter away from the midline, 137 cm above the right heel, making an exit wound, which is a lacerated wound with elevated margins of size so and so. But if he's in a vehicle and he's shot from the above and the travels from the right side and goes out, it's very difficult to envisage that it's a extremist encounter.
My lord,
Because the vehicle is not shot from the above.
No.
So the bullet to entry, make entry here and to come out from the left side
Malad,
with elevated level.
the owns and the PM report, Malad, definitely, Malad, I'll explain, Malad. Malad, in fact, if kindly give me some time, Malad, I'll analyze it, Malad. Otherwise, Malad, I am, as per the last order, Malad, I am on that impression that Lordship will, whatever the report has come from the, as regard the judicial inquiry, after that, Malad, we'll proceed for that, the hearing. Malad. The records are available with us, Malad. I'll place it and I'll also explain. Malad.
No, we're just trying to analyze because
Lot.
with the absence of the armory report, the weapons used, the recoveries made,
Lot.
the
In fact, I have called for the entire record. That is the branch Malad I have received. I'll see Malad,
because if
Logic has indicated, I'll also examine that.
because if you see if somebody is in the vehicle and you were shot, then the vehicle after the exit wound, the bullet would be available in the car. It won't go anywhere else. And therefore, you see, it has to be that the person is out in the vehicle, and then you can't recover that bullet. Otherwise, if it is in the vehicle, you'll find it. And he's not been shot straight at the straight angle from this one.
From sideways.
That's why it's very difficult to accept. We have to recreate that scene.
Lot.
Okay. Mr. Chaudhary, we'll have to wait for some time to get the subdivisional judicial magistrate's report. It's not available.
PM report to this one. PM report to this one. PM report to this one. PM report to this one.
Mr. M. Chaudhary, learned senior counsel, assisted by
PC Chakraborty.
Mr. PC Chakraborty, learned counsel for the petitioners. Also heard Mr. D. Nath, learned senior government advocate, along with Mr. R. Talakdar, learned counsel for respondent number, learned government advocate for respondent numbers 1 to 7. As well as Mr. Who's for respondent number 8?
8, Mr. B. Prasad, he appears, Lord. Possibly.
Okay, it's not there today. Okay, there's no representation of the respondent number 8. Next part.
I'll inform him, Lord.
Pursuant to order dated 9/9/2024, a report of the Lanet Subdivisional Judicial Magistrate within bracket M Gosaigaon dated 26/9/2024 is received in seal cover. Next paragraph. We have opened the seal cover and perused the status report. So it appears that only the IO has been examined so far, and the evidence of 2 constables who were present at the place of occurrence is yet to be recorded. Next one. The courtmaster shall is section given after copy. Section, okay. The AOJ Tribunal. The AOJ readable section shall provide a photocopy of the report of the subdivisional judicial magistrate within bracket M Gosaigaon to the learned counsel for the petitioners as well as to the to the learned senior government advocate. Next paragraph. Having seen that the that is some delay in the judicial inquiry by the subdivisional judicial magistrate and within bracket time account. The court is inclined to request the settlement court to expedite the inquiry. Next paragraph. The learned senior government advocate shall inform the concerned authorities of Assam Police so as to ensure that the constables who were present at the place of occurrence, the two constables were present at the place of occurrence, be produced before the Learned Subdivisional Judicial Magistrate M. Gosaigaon. So as to enable the recording of the statement of this to police personnel. Next paragraph. In the meantime, the Learned Subdivisional Judicial Magistrate M. Gosaigaon shall also inform the jurisdictional police station about the next date fixed for the proceedings so that the two constables were present in the place of occurrence be produced, if not already produced.
If not already, Lordship.
Next paragraph. We hope and trust that the judicial inquiry will be concluded in a expeditious manner. As expeditiously as possible. Next paragraph. The Learned Subdivisional Judicial Magistrate M. Gosaigaon shall send a report in a seal cover to this court, so as to reach the court on at least 1 day prior to the next date of listing. Next list on. 9/5/2025. Next
Lordship.
paragraph. The Learned Senior Government Advocate shall also transmit a downloaded copy of this order
Lordship.
to the jurisdictional police stations so as to produce a downloaded copy of this order before the subdivisional judicial magistrate.
That's me to do.
No, not that. Don't say that. You say that the registry shall transmit a downloaded copy of this order to the subdivisional judicial magistrate M. Gosaigaon to bring the order to the notice of the Learned Court.
Lordship. I'll do it through the SP. If the constables are not there, I'll do it through the SP.
Yes.
I'll do it. Lordship.
And we are not putting into the order, but kindly have a word with the forensic experts so that we can try to reconstruct that
The scene.
scene.
Lordship. I'll do it.
How it is to be done, we don't know. We just forgot.
I'll do it. In fact, during the course of inquiry, as I have seen in other cases, my lord, during the course of inquiry, they used to create a scene. The scene is created and accordingly the inquiry is done. I'll apprise, my lord. The
We
records
get
are with
instruction
us.
because I
We'll
just
I'll
forgot.
apprise. I'll apprise.
We don't do it regularly. I tend to forget.
Lordship. Well, the records which I have placed, I'll keep my lord,
No, you can
on a
take it
next
back.
date. On a next date, I'll place. Lordship.
Item 7 for hearing.
Also, in this matter, the senior is not able to appear to this matter. The reason is that he had one little son. He had some medical issue, Lordship. Senior son has had that medical issue, Lordship. I tell 7 and 8, Lordship.
We are adjourning it, but on Tuesdays and Thursdays, we are not adjourning the matters without a prior intimation. Today we are doing it, but next time it will be refused. You have to, Tuesdays and Thursdays, we are listing less matters. Tell us in advance, otherwise we'll refuse adjournments on Tuesdays and Thursdays.
Okay, Lordship. Next.
Upgraded item for hearing, supplementary item 19 to 67.
Deeply obliged, Lordship.
Yes.
I mean, led by Mr. Das is on legs. There are other seniors also in this matter. I've informed him already.
We can take it up at 2 then, because we hardly have time.
Yes.
Resume at 2 then.
Grateful, Lordship. Leadership.
Item 8.
Yeah, John, what my question about that? Adjourn করেছিলেন। Adjourn করে দিয়েছিলেন। Thank you.
No,
6 and 9. Huh? Seven and 8. 7 and 8. Right. It's really good. 7 and 8.
Time to look.
Item 14.
May I please, Your Lordship? Lordship, this PIL has been filed by Tihu Nagar Indian Committee. This is an organization which is a registered organization. But basically, it's a it is kind of a welfare society looking after the various issues of
What is PESO?
what's it, PESO, petroleum explosive. I'll just give Lordship.
It's a petrol pump.
Yes, madam.
It's a petrol company.
How will
PESO.
PIL be maintainable for a petrol pump allotment?
So Lordship, this has been, we are basically challenging this on 3 counts. First thing is that this is in violation of the siting criteria which has been prescribed by the Central Pollution Control Board. Secondly, we are challenging this because the Deputy Commissioner has issued that NOC, which is a mandatory NOC which is required under the Petroleum Act, which has been done not as per the Petroleum Rules 2002. Thirdly, we have also pointed out the person who has been given this petroleum retail outlet, she is not qualified to be given this petroleum outlet. That as far the qualification is concerned,
You
Lordship,
see-
we are not much on this, that they will
Just a
decide
moment.
their company.
Just a moment.
No, sir.
Was there any, except for the person who has been selected in the application process, are
Lord-
there any other applicants?
Lordship,
In
No.
this application process,
correct, Lordship.
was the private respondent the only person who's applied, or there are other participants in the process?
There were other participants. There were other
So
participants.
this-
3 participants.
All these people have no objection. How will the
No,
public interest be maintainable?
Lordship, we are concerned with a major issue, Lordship. This has been given, the siting has been given adjacent to a school. As per the Central Pollution Control Board, it cannot be given adjacent to the school. There has to be some parameters of giving it. There has to be some inquiry. There has to be some NOC from the school, because the health of the school children is in danger. Because continuous exposure to these petrol pumps, this vapor, that creates cancer, Lordship. I have the reports with me. And this cannot be given, and NOC cannot be given in violation of the petroleum rules. And this society being a society there, which looks up, it's a school of around 600 students. Their health is in danger. The NOC has been given in total violation of the petroleum rules. And this has been given to a person who is not qualified. As per their own company's brochure, the person has to be 10th pass. She has in fact failed in 10th. That has come after the RTI application, that has been brought on record by the company itself. And in spite of that, the company hasn't terminated the license as yet.
India is one of the largest group companies.
Correct.
Is owned by a person who is 8 pass.
Lordship, that is their brochure. I don't have anything to say on this, because my cause is, Lordship, my only cause is I'm only concerned with the health of the students, nothing else, Lordship. If the citing criteria, if they put it in a different place, I don't have any issues.
I had read an article that a delegation, I'm not naming the person, a delegation went to a foreign country to visit industry. And this man saw the industry, came back and replicated it here without any notes.
That is there. I appreciate that is there. That is there. I'm not much on that, Lordship. I'm not much on qualification, because that is their concern.
ultimately they have some accountability towards the public also. There are other applicants also there who applied for this. Probably they are qualified to get it, but they didn't get it because of this. I mean, the person who has actually suppressed that she has stated that she has metric pass, but she is not in fact metric pass. That has come on
And
record.
in my own home, I had a mother who was not metric pass, but she
Grants,
groomed me up to
correct. That is there.
become a graduate.
That is there. That is there. So I am basically concerned with the health hazards of the students. The students are there from
Shows that rules where it is prohibited.
Page 131, madam.
1 second. Let me finish it. Then we will argue. Lordship may kindly first, Lordship, because I am contending that this is not as per this petroleum rules. So Lordship may kindly take up the Petroleum Act 1934, Lordship.
We will continue after.
Petroleum Act 1934.
We'll continue post lunch.
Yes.
Yes, Lordship.
Petroleum Act, which are the electoral rules you require?
Yes, I'll tell.
Petroleum Act.
Petroleum Act 1934.
Okay. We may be 5 or 10 minutes late in assembling again.
Lordship.
It will be nothing to do.
Huh? Oh, it's up there. But yes,
Lordship. Lordship,
We'll also be taking up that APSC matters.
Lordship.
So let it come after view vacation. What says the representative? Due to positive time, the matter could not be taken up for hearing. List after ensuing vacation. So liberty granted to land counsel for both sides to make a mention if the matter is not listed.
Lordship.
Item number 19 to 67.
So Das is appearing, he's on his legs, he will resume, but there are other councils, they can argue.
Anybody can start.
Lordship, if I may, Lordship, this matter came up suddenly yesterday, Lordship, in the supplementary list. It was not fixed on this particular day, Lordship. So, Lordship, because there are voluminous records, we are in at least 8 cases, Your Lordship. So we could not prepare, Lordship. I may pray for a date after vacation or fix it after vacation, Lordship. We'll argue
Because
on that.
because to take up these matters, we adjourned just now. We adjourned another matter.
Lordship. We could not prepare, Your Lordship. It
No,
came up
that's
suddenly,
okay. But
Lordship.
mention should be normally made in the morning. We could have accommodated all other matters. We are adjourning other matters to take up this.
Apologies.
And since he is also coming from auto station. But there's nobody else who wants to start. There are many matters. Nobody wants to start. Suddenly you are unemployed.
I'm feeling also the same. But I must say, Lordship, I was inquiring that Lordship had, I think, a surgery in the eye because I was wondering Lordship was wearing it. So I was thought maybe it's,
Men in black.
but Lordship is looking nice. On a lighter note, is looking nice. I mean, we are prepared, of course, but I guess we
See,
have
the
no choice.
advantage of this is I can now look at the darker side of everything.
Lordship, there's another part. We can't see Lordship where you're looking. We have to be alert all the time.
No, but then when is the next date is very uncertain because after vacation we are
Lordship, I know I've been from morning seeing because we are actually finishing off matters and those fast track. Last time also you had mentioned about those foreigners tribunal matters, they're old matters, you're closing them. I can only pray subject to your indulgence, Lordship, because I come from outstation. If it's convenient, if dates are indicated in advance, it just becomes a little easier to come in. But rest, I leave it to Lordship. Because this is not that kind of matter where on VC, I think one does justice.
So Lordship can have it on 29 Lordship if preferable to this honorable court.
29th.
29 Lordship.
Or Lordship first week, May. First, second, sixth, seventh, whatever Lordship says. If Lordship would be even considered to keep it 2 days consecutively, it will give them also a lot of chance to finish and for us to respond simultaneously on several petitions. First is very good.
First of May, sir.
1st and 2nd of May.
I am so grateful, Lordship. I am deeply obliged to that too.
Okay. But both sides, including Mr. Nalin Koril and the Senior Counsel for the Senior Counsel, assisted by Mr.
A. Roy and
Roy.
N. Menon, Nimisha Menon. 2 people are there.
And Counsel for the state.
Yes.
Are present. Next para, the joint prayer is made by the Learned Counsel for the.
Lordship, I get in difficulty when there is a joint prayer.
No, by the appellants.
I'm grateful, Lordship.
Sorry, by the Counsel for the Learned Counsel for the appellants that the matter be adjourned. Full stop. Next para. Prayer is considered and allowed. List the matter again on 1/5/2025. So both parties, both sides have to notice that if required, the matter would be also taken up on the next consecutive day.
I'm so obliged, deeply obliged, Lordship, and wish you get well soon, Lordship. How are you? Deeply obliged. Leadership.
You don't want me to look at the dark side of the life.
Actually, Lordship last time also had another comment on which I had no response then. I was telling my colleagues for the first time I found myself without a comment. Grateful, Lordship.
Mr. Kalita, can we take up your matter then? If the board is falling.
We can, Lordship. If your Lordships are willing to take, we are willing.
Because if it's better to do something than to retire.
Lordship, before taking your Lordship to the Petroleum Act, Lordship, I would like to point out certain provisions from the brochure. So Lordship may kindly come to page 50, Lordship. So Lordship, this is the brochure published by Indian Oil, Bharat Petroleum and HP. So this is for the selection of dealers, regular and rural retail outlets. So I would just like to point out one provision from here, Lordship. Have you also got it? Page 53, Your Lordship. So page 53, serial number 4. It says about the eligibility criteria for individual applicants, proprietorship and partnership. So under 4, serial number 4, educational qualification. So it specifically gives lots of educational qualification as past minimum 10th examination conducted by board and school. Then Lordship will find page 79. What happens, Lordship, if there is some kind of misrepresentation or suppression of facts? That at page 79, false information. If any statement made in the application or in the documents enclosed therewith or subsequently submitted in pursuance of the application by the candidate at any stage is found to have been suppressed, misrepresented, incorrect or false, then application is liable to be rejected without assigning any reason. And in case the applicant has been appointed as a dealer, the dealership is liable to be terminated. In such cases, candidate dealers shall have no claim whatsoever against the respective oil company. So this is very clear. This is their document, Lordship. They have set a benchmark that 10% is required. So now, Lordship, I'll take your Lordship to the citing criteria, Lordship. Citing criteria, Lordship, will find at page 126. So what has happened, Lordship, prior to this issuance of the guidelines, that there was a kind of a mushrooming of a lot of petrol pumps happening in all urban places and rural places also, near schools, near residential societies and residential places. So because of that, some persons have approached NGT, and NGT has took cognizance of the matter, and they have issued an order to pass a guideline to the Central Pollution Control Board. And accordingly, Lordship will find at page 126, Central Pollution Control Board has issued these guidelines. It was issued in January 7, 2020, Lordship, Annex 5, page 126. May I read out, Lordship?
Just a moment.
Yes.
Just a moment.
Sure.
Page number?
Page number 126 here also.
126.
126 also. Annex 5. The subject is, Lordship, guidelines for setting up of new petrol pumps in compliance of the NGT order dated so and so. Honorable National Green Tribunal wide order dated so and so directed Central Pollution Control Board and Ministry of PNG to look into the issue of setting up of large number of petrol pumps in the country and directed that appropriate guidelines be issued by the Central Pollution Control Board in exercise of statutory power. An expert committee comprising of members from IIT Kanpur and NERI, IIP, TERI, Ministry of PNG and CPCB was constituted to frame guidelines for setting up of new petrol pumps, including siting criteria and pollution prevention and control measures. The guidelines were placed in the public domain, and comments, suggestions, and objections were invited from the public and concerned stakeholder, and these were reviewed and guidelines have been finalized. The final guidelines prepared by the expert committee are hereby circulated for implementation by the concerned stakeholders. These guidelines are hereby issued with approval of the competent authority. Now, Lordship will find at page 131. Page 131, Lordship, that's a citing criteria, serial number H. So in case of site,
Just a query, this Central Pollution Control Board,
Lordship,
is their guidelines applicable in the state of Assam where we have our own pollution control board?
Lordship, it is, Lordship, they have filed, Central Pollution Control Board has filed an affidavit already, Lordship. And
No, filing of affidavit is one thing, but what is the legal implication? The state, when there is a state pollution control board
Yes,
available,
Lordship.
can the Central Pollution Control Board take over and decide for the state of Assam?
Lordship, it's a Central Pollution Control Board has delegated the issue to the Assam Pollution Control Board. They have regional authorities placed in all the regions, Lordship. So all the regions will implement their Central Pollution Control Board guidelines, Lordship.
Might find it page number 169 minute.
169.
69. Central Pollution Control Board has circulated the guideline to the state pollution control.
Yes, Lordship. That is their pin 169. I'm thankful to my learned friend for pointing out this.
Okay. So implementation will be by the Assam State Pollution Control
Yes,
Board.
Lordship, yes.
Okay.
So now page 131 of Lordship will find the citing criteria of retail outlets.
Yes.
In case of citing criteria, petrol pumps, new retail outlets shall not be located within a radial distance of 50 meters from fill point dispensing units, vent pipe, whichever is nearest, from schools, hospitals are 10 beds and above, and residential areas designated as per local laws. In case of constraints in providing 50 meters distance, the retail outlets shall implement additional safety measures as prescribed by PESO. PESO, Lordship, was inquiring about PESO. PESO is, Lordship, Petroleum and Explosives Safety Organization. In no case, the distance between new retail outlets from schools, hospitals, and residential areas designated as per local laws shall be less than 30 meters. No high tension line shall pass over the retail outlet. So this is the citing criteria, Lordship. So as per my submissions, Lordship, the citing criteria which has been prescribed here, that hasn't been properly followed, that hasn't been properly inquired, because the retail petrol pump which has been set up, that is adjacent to the school. It is adjacent to the school, and they have just stated that it is within the perimeter of diametric perimeter of 100 meters. And that inquiry hasn't been done properly. That is my allegation, Lordship. Now I'll come to
It's
the
not 100 meters, radial distance of 50 meters from the
no, that is they are
from the fill point.
Correct, Lordship. Correct.
From the fill point.
Fill point or which fill point, dispensing unit, vent pipe, whichever is the nearest. So that has to be calculated properly. That has to be seen. Then only NOC can be issued. So without calculating that the distance properly and without inquiring it properly, whether that NOC can be given or not, that is my submission. And Lordship, I will bring to your Lordship's notice that what happens, Lordship, when a petrol pump is there near the school, Lordship. There are certain reports from the lot of medical journals and all, where it has been specifically stated that petrol pumps near, if children are exposed to petrol pumps, what kind of diseases they can have. And that is the concern of the society, Lordship. The Lordship will, I'll take your Lordship to page 138, Lordship. So this is the prior approval has been given by the Petroleum and Explosive Safety Organization, Lordship. It was issued on 18/3/2020. So Lordship will kindly come to the bottom part. On completion of the construction as shown in the approved plan, please forward the following documents for grant of license in Form 15 of Form 14 of Petroleum Rules 2002. So Petroleum Rules is the applicable rule under which this NOC will be issued. Now Lordship will find as page 139, this is a mandatory documents they have to submit, Lordship. This is the serially, Lordship, this has been given 1, 2, 3, 4, 5, 6, 7, 8. So relevant one is, Lordship, serial number 5. So serial number 5, Lordship will find the original copy of no objection certificate from the district authority together with site plan duly endorsed by him with his official office seal thereon. So this has to be, NOC has to be given duly endorsed by the concerned officer with his official seal thereon. Now may I take your Lordship to page 140, the next page. Lordship. Next page is the Lordship no objection certificate NOC, which has been mentioned there. That has been issued by the Deputy Commissioner Nalbari. So this has been issued on a letterhead, Lordship, of the Deputy Commissioner. The contents are, I'll just read out, Lordship. Name of the applicant is there, purpose is there, proposed site and land has been, DAG number and etc. has been given. And verifying agency in the field, the circle officer Tihu, revenue circle verified and verified the site and submit status report of land as shown above. Then comments of the district authority. District authority is the Deputy Commissioner. There is no objection for obtaining license from Petroleum and Explosives Safety Organization, Ministry of Commerce and Industry, Government of India by the applicant for the site proposed. Reference Rule 144 of the Petroleum Rules 2002. This is very important, Lordship. Subject to conditions that the applicant will observe all formalities as required under the all relevant acts and rules. Now, Lordship, may kindly come to the next page, Lordship. Next page, Lordship, this is the site plan they have given. Now, this site plan, Lordship, that signature and the seal is from the circle officer TU, district circle. He is not the issuing authority. The issuing authority is the district commissioner. I will come to that petroleum rules law that has been specifically stated. The person who has issued the certificate NOC, he has to sign there and put his seal there. It hasn't been done by him. It has been done by the circle officer. The circle officer is not the authorized authority. Now, at this stage, Lordship, I will take a Lordship for the petroleum.
What you are essentially arguing is against the statute.
Lordship?
What you are essentially arguing is against the statute, the Assam Land and Revenue Regulation,
Yes.
Which refers to the settlement rules and the issuance of the maintenance of record of rights is done by the circle officer.
That Lordship, as far as that provision is concerned, Lordship, I am not very much aware of this. My Lord, let me be honest about this. But as per the statute, that district,
No, because you see, we have that experience in the trial court because we deal with the
correct,
land maps and all day in and day out.
correct.
So circle officer, a deputy commissioner doesn't countersign because he's not the issuing authority of the trace map. A trace map is maintained at the field level, and therefore it is the assistant settlement officer when the settlement operations are going on, or otherwise it reverts back to the circle officer.
Lordship, I'm not very much aware of that. I'm extremely sorry about
No, it's
this.
okay. It's,
Yes, Lordship, but like as far as rules are concerned, also, I'm just pointing out to your Lordship.
Okay.
The rules, Lordship, the petroleum.
You see, the difficulties are at times, there are many things which happen,
Lordship.
but we'll tell you the mindset of the officers who work on it. I'm not on this particular case. I'm I'm making a general statement.
That is.
You see, there's one matter which we have dealt with, and I'm giving you that reference. You see, in foreigners cases where the
Yes, yes.
where the superintendent
Yes.
of police makes the direct somebody to make an inquiry.
Right, Lordship.
The police, the constable goes there, makes an inquiry, but they are always trained not to take the signature of the accused. Therefore, what happens is that essentially in all the proceedings you would have found that the statement of the proceeding is recorded and it's not signed, but in the Foreigners Act, the Foreigners Order, the
Yes,
requirement
right.
is that they will take the signature of the statement because this is a civil foreigners
yeah,
proceedings
that is civil
is a civil
proceeding.
jurisdiction,
Correct. Yes.
and it is only for the purpose of a criminal jurisdiction where 27 comes in and no statement before the police officers is valid.
Absolutely.
But they are trained in a manner
Hmm.
that unless they are they undo it, they will not take the signature of a person because they think that he is an accused.
Mindset is that.
Mindset is that.
Correct.
So therefore, in these litigations which come up, even if some law says that the deputy commissioner will do it, the deputy commissioner thinks that it is beyond his too much below his authority to sign that document.
Correct.
So there lies the difficulty.
Yes, Lordship, that's true.
And this is another example which I can readily give. You see, the after the decree is passed for partition,
Yes, Lordship.
it's sent to the district commissioner to deputy commissioner to do the needful. He gives it to the circle officer to do the needful, and then this delegation, which goes to the circle officer because that's not maintained. Because the direction is to the deputy commissioner to get it done, and deputy commissioner delegates it to the
Somebody
others,
else, circle officer.
and therefore they go by the prescription
Correct.
of delegated authority under the rules of executive business.
Correct, executive business. They go by that, yes.
They go by that, and since it is delegated, they have it done through the circle officer, and it's all done.
So they don't usually check whether the authority is there or not.
There lies some difficulties.
Correct, Lordship, that's true.
We are not on your case.
I
We are just giving a
understand. No,
general.
I understood, Lordship. I truly appreciate this, Lordship.
Yes,
Now, Lordship, Petroleum Rules 2002, Lordship.
yes. Petroleum rules.
Yes, Lordship. So this NOC has been issued under Rule 144 of Petroleum Rules 2002.
Petroleum rules.
It's together with the Petroleum Act, Lordship.
It's there in the act.
It's there in the Act.
Oh,
Lordship.
acha.
It's there in the Act.
Okay.
So Rule 144, Lordship, prescribes how NOC has to be issued.
Yes.
So 144, no objection certificate, where the licensing authority is the chief controller or controller. Here, Lordship, licensing authority is the chief controller only, that Lordship, PESO chief controller. As the case may be, an applicant for a new license other than the license in the forms of so-and-so shall apply to the district authority with 2 copies of the site plan showing the location of the premises proposed to be licensed for a certificate to the effect that there is no objection to the applicant receiving a license for the site proposed, and the district authority shall, if he sees no objection, grant such certificate in the pro forma specified in sub-rule 7 to the applicant, who shall forward it to the licensing authority with his application form 9. Note, the licensing authority shall accept the no objection certificate within a period of 3 years from the date of its issue for considering the grant of license. Serial number 2, Lordship. Every certificate issued by the district authority under sub-rule 1 shall be accompanied by a copy of the plan of the proposed site duly endorsed by him under his official seal. So it is, Lordship, district authority is the district deputy commissioner who has issued the NOC. So site plan has to be endorsed by him.
No, district authority is defined in rule
Yes, Lordship.
Correct,
210. Lordship. Yes, Lordship, it's defined.
District authority means
Yes,
in
Lord.
towns having commissioner of police, the commissioner of
Commissioner or deputy commissioner of
deputy
police.
commissioners of police,
In any other place, district
district
magistrate.
magistrate,
So district magistrate Lordship is equivalent to district deputy commissioner.
deputy commissioner.
Deputy commissioner. So deputy commissioner has issued this NOC. And as I have shown your Lordship that like this has not been endorsed by the deputy commissioner. Now Lordship, further to that. Now Lordship, 3, 4, 5, 6 is 5, 6 are not very relevant to our case. Rule, so Lordship, sub rule 7 is very important, Lordship, for our case. Sub rule 7, your Lordship.
This document you're showing at
140.
140
Yes, Lordship.
is signed by Deputy Commissioner Nalbari.
Deputy Commissioner Nalbari.
Yes.
And Lordship, this endorsement that has been made by the circle officer, Tihu.
Yes.
So
what
it's
is 44 says where licensing authority or so and so, any applicant license shall apply to the deputy to two copies of the site plan showing the location of the premises, certain no objection to so and so. So this does not say that the site plan has to be signed by the deputy commissioner.
The Lordship, sub rule 2, Lordship.
Every certificate issued by the authority under sub rule 1. Sub rule 1 relates to the no objection,
Yes, no objection, Lordship.
not the site plan.
The Lordship, kindly read out.
Every certificate issued by the district authority and sub rule shall be accompanied by a plan duly endorsed by him under his official seal.
Site-
Okay.
Site endorsed by under his official seal.
Okay. Okay.
So
You're
site plan
right.
has to be endorsed by him.
You are right. Yes.
Now, Lordship, sub rule 7 is very important, Lordship.
Yes.
Sub rule 7 is basically the pro forma of no objection certificate, Lordship. So district authority shall issue a no objection certificate in the following pro forma, namely so and so. So Lordship, I'll just read out the subject no objection certificate with reference to application number so and so submitted in pursuance of rule 144 of the Petroleum Rules 2002. There is no objection for granting license under Petroleum Rules 2002 to Srimati so and so, address so and so for storage of petroleum products in their premises at survey number so and so, as shown in the site plan duly endorsed and enclosed herewith. Now, 1, the following particulars have been considered while issuing this no objection certificate. This is very important, Lordship. These aspects have to be considered. It has to go under the in the pro forma. The following particulars have been considered while issuing this no objection certificate: that possession of the site by the applicant is lawful and authorization from landowner or leaseholder for developing premises under these rules for storage of petroleum products. Interest of public is very important, Lordship. Interest of public, especially the facilities like schools. Especially the facilities like schools, hospitals, or proximity to places of public assembly and mitigating measures, if any, is provided. Traffic density and impact on traffic, conformity of proposal to the local or area development planning, accessibility of the site to fire tenders in case of emergency, and preparedness of fire services for combating the emergencies, genuineness of purpose, any other matter pertinent to public safety. Signature of the district authority issuing no objection certificate with his seal is required. So Lordship, these aspects has to be specifically stated in the NOC. And in my humble submission, Lordship, none of these aspects have been done, Lordship. No public hearing took place. The school which is adjacent to the petrol pump, the school authority was not discussed. No objection has been, approval has been taken from them. Approval is not required, Lordship. But at least consent from them, the school children are studying there, what will be the effect, nothing has been discussed. Simply in a very careless manner, this NOC has been issued. Now, Lordship, at this stage only, Lordship, I'll take your Lordship to a case which has been decided by the Supreme Court, Lordship. Before going to the other aspects, since I'm submitting on this, Lordship, I'm just placing the case note.
Correct.
2019 SSC online Madras 4746. Lordship, it's not by a Supreme Court, Lordship, it's a court by a court of Madras, Lordship. I'm sorry, Lordship. In a similar case, Lordship, division bench or the Madras High Court. The relevant paragraphs are paragraph 3 to 8, Lordship. May I read out, Lordship?
14 to 21.
August 5, 2019. August 4.
Yes.
From paragraph 3, Lordship. A similar matter, a similar issue has gone on the issue of NOC, Lordship, is a Madras High Court division bench, Lordship. Paragraph 3, Lordship, may I read out?
Yes.
The learned counsel for the writ petitioner submitted that petroleum rules specify that no objection certificate should be obtained as per Rule 144 of the petroleum rules before undertaking the business of establishing and operating a petroleum retail outlet. He further submitted that for this purpose, an inquiry should be conducted so as to ascertain various aspects, including whether the possession of the site is lawful, whether the interest of the public and the facilities like schools, hospitals, etc. are affected, the impact on traffic, the conformity to local or area development planning, accessibility of the site to fire tenders and other matters pertinent to the public safety, etc. In this case, he submits that the impugned no objection certificate was issued by the first respondent without ascertaining whether the above mentioned requirements were satisfied. In this regard, he referred to the no objection certificate dated 9/1/2019 and pointed out that it merely states that the above mentioned particulars were considered, but that no details are provided with regard to the satisfaction of the said requirements. In our case, Lordship, nothing has been mentioned at all. Here, at least something has been mentioned, saying that those are complied with. But in our certificate, nothing has been mentioned. In response, the learned counsel for the 7th respondent submits that the 7th respondent is ready and willing to go back before the said respondent for the fresh inquiry into the matter. In such event, he submitted that 7 respondents as well as the petitioner herein would be in a position to place all the relevant materials for consideration of the first respondent. The learned additional government pleader also submits that matter may be remitted to the respondent for fresh consideration in accordance with Rule 144 and the requirements specified therein with regard to grant of no objection certificate. On perusal of the no objection certificate dated so and so, it is clear that the requirements of pro forma no objection certificate under petroleum rules are reproduced therein. However, we do not find any discussion or finding as to how it was ascertained that the said requirements were satisfied with regard to the 7th respondent. In addition, it is seen that Rule 144 envisages that an inquiry should be completed within a period of 3 months from the date of receipt of application before issuing no objection certificate. In this case, the impugned no objection certificate does not disclose that such inquiry was conducted. So nothing has been done in our case, Lordship. In this instant case, nothing has been done very casually, Lordship. The NOC has been issued. The school was adjacent to that. Around 600 small, minor children. They are studying there. They are exposed to, Lordship, this very harmful hazard. There is a content called benzene. The benzene, the evaporation of benzene and inhaling of benzene creates cancer, Lordship. There is a study by a lot of European countries. Like especially the minors, children, if they're exposed to that, it's very cancerous. 35% of the students got cancer, Lordship, because of this kind of exposures. And that is why, Lordship, these guidelines have been issued. That is why NGT has taken cognizance of the matter and issued that the citing criteria has to be very, it's a very important aspect of the matter, and citing criteria has to be strictly adhered to. But nothing has been done in this case, Lordship. In addition to this NOC, Lordship, other aspects, Lordship, as far as Lordship, some kind of misrepresentation on the part of the respondent number 7. How they have suppressed these things, Lordship. I'll just show, Lordship. Lordship will find at page 142, the lease agreement that they have submitted before the company, Lordship, while submitting their application.
Page
142, it starts, Lordship. I'll just take your Lordship to the relevant page at 154.
Yes.
So page 144, Lordship, the schedule of the land is given, Lordship, that particular plot where this retail outlet has been set up. If your Lordship peruses this at the bottom, Lordship, of page 154.
Yes.
How they have given this schedule. On the east, Tihu Feeder Road. On the south, remaining part of duct number 666. On the west, remaining part of duct number 666. On the north, land bearing duct number 666, 662. Nothing has been specifically stated. Lordship, the school is there. Adjacent to it, no mention has been made here. Lordship. Just simply referring to the duct numbers. They should have gone with a clean hand, Lordship, before the authority, before in their application. They should have at least mentioned the school is there. Yes, sir.
I always follow up on this book when I
Yes.
don't have any answer.
Yes.
You
Yes.
see, Order 7, Rule 3.
Yes, Lord, sir. Yes, Lord, sir. May I read out, Lord, sir?
Just for your consumption.
Yes,
not.
Very good. That is there. Lord. That is there. Lord. Obliged students. So, Lordship, that is there, Lordship, that is there. So now, Lordship, as Lordship, I was pointing out that NOC, as far as the school is concerned, Lordship, page 181. The school was not consulted, Lordship. That has been, a letter has been issued by the school, Lordship, page 181.
Yes.
With reference to the subject cited above, this has been issued by the Sarveswar Das Senior Secondary School, which is the concerned school. A principal has issued this lordship. With reference to the subject cited above, I have the honor to inform you that I have not given any NOC to establish a BPCL petrol depot near our educational institution, and the said depot has not occupied our land. That as in Tihu is a town area, the matter would be under the knowledge of town committee. That what it has basically stated that school has not been consulted. Now, Lordship, though it is obviously, Lordship, this is kind of this is a PIL, and I may not be vouching much on the educational qualification, but just to point out, Lordship. Yes, sir.
Mr. Bhattakur, if we only have one point of this school in the periphery.
Yes, sir.
And if we look at page 192, does not appear that from the filling station, the school campus is more than 50 feet away.
But it's required only about 30 meter. Minimum 30 meter.
This is not only 30 meters. It can't be. The man is standing. A man
Sir.
would be 5 meters, 5 feet.
No, from the filling for the dispensing unit, madam.
We understand. There's a man standing here in page 192.
Yes, madam.
Correct. The man would be 5 feet.
Yes, madam.
Correct. So 5, we can place 4 people. So it will not be 20, more than 20 feet. 20 feet will work out to 7, 8 meters.
From the school, on the boundary, from the boundary line, my lord.
School is, every part of the school is
Yes,
a school,
that I understand, my lord.
boundary or not.
Yes, Lord. They roam around in the boundary. They organize a lot of festivals there, like Saraswati Puja and all these things, Lordship. This
No,
is
whatever
required.
we, but school means school campus is
ma'am.
every inch of it.
The minimum distance should be 30 meters, at least 30 meters.
So if not the authorities will have to re-examine and the issue
Yes.
fresh.
Before the matter, kindly see, my lord, who came before this court, my lord.
That will come, that he can argue.
No, you
Lordship.
see,
Yes, but there is a greater public interest is there, my lord.
no, it's not,
That I understand,
no,
madam.
no, it's not an issue of that. Because you appear for the
BPCL.
BPCL.
Yes, sir.
And BPCL cannot say, since it's a state-owned institution, it can't say that the applicable rules would not apply on them. Correct. Now, if a basic requirement is of let us say 30 feet, 30 meters according to you, the authorities will have to re-examine and then issue it. This and the NOC not being in the form, one ground is good enough to send the matter back to the authority.
At the same time, I will see, my lord, whether these guidelines can be, my lord, enforced before the court of law, my lord. You see, it's an instruction or guidelines, my lord.
You give a statement on oath that BPCL does not intend to follow
No,
the
no.
guidelines. We'll make the work easier. We'll dismiss the petition. You just have to come and say that the brochure is not meant for being enforced. Good enough for us.
But this is a pollution control guidelines, madam.
No, we understand.
Yes, ma'am.
But if you don't, if it is not for you to follow,
Yes, ma'am. We have to follow, my
just,
lord.
just file an affidavit. We dismiss the petition
No,
in
no,
Albany.
But we have to follow, madam. But when, by going through the Supreme Court judgment, madam, that's why I am submitting, madam.
But it's okay. They have to, if the act says do it in a manner, it has to be done in that manner alone.
At the same time, madam, see, madam, who came before this court, madam. Madam, we will, madam, examine, madam.
No, you see, let us say that this, the petitioner,
Yes.
he's a stooge. What would be a good word? I don't know. He's a setup person. Correct.
Because the.
It's okay. Maybe he is a participant.
No, madam.
We take it. Worst to worst is that let us assume that the petitioner
He
is
is
a
one of the
participant.
partner of nearby petrol pump, madam.
That's okay.
Yes, ma'am.
But you see,
Let them so
still, if the issue raised is a violation of the statutory rules, what happens? He's a competitor. He wants to call out competition.
But
Correct, we
madam,
accept
the-
it.
Then, madam, the things should be refined, madam. Because if you could not, madam, succeed in the process, madam.
But still, it's a violation. It is not your case that the petitioner, when he applied for the license and he offered the same land.
No, madam.
So why can't a competitor come and stop competition?
But he is not a competitor, madam. If
No, let us
hypothetically,
assume,
madam,
no, no. Let us assume for the
Yes,
worst.
madam. That's what I'm
We
saying.
take it up that he's a setup person and therefore the persons from who have set him up, set the petitioner up for this, he has a vested interest.
Yes, madam.
Let us assume it for the time being. But what happens to the statutory violation?
That we have to follow, madam. That I understand, madam. That we have to follow, madam.
Has to be examined by the
Yes,
deputy commissioner.
Yes, madam.
Lordship,
And so far, my education qualification is concerned, madam, I must clear.
Those things we are not on
Yes.
much on that. It can be
The
relaxed,
inquiry
it
is
cannot
going
be
on, madam.
relaxed.
Lordship, they have in fact taken steps to terminate this retail outlet because she has submitted false documents. So we have brought
No,
it on
that is-
record, Lordship. And Lordship was there.
Those things are,
There's an affidavit file, Lordship.
But I in singular dealt with this matter, madam.
that is, that you see, a termination will come when the termination, cause of action for termination arises.
Yes,
Lordship.
But that cannot be a ground to preempt an agreement to
Yes,
come up.
absolutely, Lord, absolutely. I fully agree with you.
So if despite that document, they set up, then you always have a right to come and say that this is a
That's-
false
that-
document.
I don't have much, but only thing, Lordship, I was pointing out that like they have misrepresented. They have suppressed the fact. She was not 10 pass out as per the brochure. She was failed. She has come approached this honorable court. Honorable court has dismissed their writ petition. My lord was sitting in the single bench, lordship. That is there in the affidavit that they have filed here, lordship.
Oh, is it?
Yes, lordship. Your lordship may kindly take out the
But
affidavit.
we are
lordship.
processing to terminate him, my lord. Only if the approval is yet to receive, my lord.
But
it's
lordship,
just-
what
I don't even show us that this.
that
Yes,
affidavit, lordship, I'll just take your lordship to the affidavit, lordship. The
I-
affidavit opposition filed by them, lordship.
Page 282, my lord.
Somebody who has failed in metric, lordship, and came before this court to challenge it. Then Board of Education has given that certification that she has failed. After that, she has withdrawn the case, lordship. And they have got this petroleum outlet by misrepresenting and suppressing the facts. And they are still protecting him, the person.
Okay, this is in our brief, it is 41. Two 61.
My lord's order is a page 282. lords.
No. It's correct number is 261. Is the first page of the order.
আমি ঠিকই তাতে বহুতে ঠিক আছে ইন্ডেক্স উপর লিখে দেবে Seba intimate asked them the private respondent fail in the examination. So thereafter, we issue so called notice. Now, after person hearing was conducted, we are processing terminate, but the approval is yet to receive from the head office. So he is happy to that extent.
Lordship may kindly see, Lordship has passed this order on 10/4/2024. Till now, they have not cancelled her, terminated her petrol pump.
But there is a process.
Why? How they are protecting her till now? How they are allowing her to run the petrol pump, Lordship? It's a public accountable,
Last one,
issue of public accountability. is there.
The hearing was conducted, the hearing was concluded,
No, that's okay. We are not on that
Yes, ma'am.
for the time being.
Would see, whether at the time of issuing the NOC, whether the
In this
district-
PIL, we
Yes,
take up the issue of
Madam,
only that.
whether the deputy commissioner
Closeness to
taken
the
into
school.
consideration the
Who's
all the
appearing for
aspects.
respondent number 7?
He is-
You're there. Is it denied that it is not within the 30-meter parameter from the school compound?
Not, no lordship. It is almost 1,000 meters, lordship. To the premises of the school.
No, it can't be. This photograph
It can't
doesn't
be.
show. Page 192 doesn't show. 100 meters is just not,
This is too much, Lordship.
just not visible here. You see, we are at page 192.
Yes, lordship.
In 192 on the left side, a person is standing.
Yes, lordship.
Correct.
Yes.
A person, we presume him to be a 5 feet. He may be taller, but we presume he's 5 feet.
Yes, lordship.
So if he's 5 feet,
If it's 6 years, then it is okay.
it can't be more than 20 feet, 20 feet. 100 feet is out of question.
100 feet is up to the premises of the school of the.
No, that interpretation can't be
In
there.
boundary, it is more than 30 feet, lordship.
Hmm? 30 meters.
30 meters, lordship.
This is 30 meters. No, can't accept it. It just can't be accepted.
Madam, may I suggest, madam, may direct the
We-
deputy commissioner to examine the distance, madam. If it is within parameter, madam, that is okay, madam.
Well, this is photograph, Lordship. I have not seen also physically.
No, you see, we have some experience in dealing with in the trial court, the Mandal's pencil,
Sure, Lordship.
correct? It is this big,
Yes, sir.
correct? Now we have a pencil in hand. We just measure the man's size from here. It comes to up to this point, the sharpened point. So this is 5 feet. So if I put this pencil from here to here, 1, 2, 3, 3.5. So if 1 inch is 5 feet,
That's the
then-
calculation, your lordship, yes.
Lordship,
I've been doing
Lordship,
some part of my life I've spent there with this pencil.
as per my instruction, Lordship, it is more than 30 feet. And as per the measurement done by the PTCL also, it is more than 30.
Deputy commissioner.
Sorry, Deputy Commissioner, Lordship.
30 feet.
In
30 feet.
Commission may be issued, Lordship.
No, we are not issuing commission. We'll delegate it back to the deputy commissioner, let him do the needful and pass a fresh NOC in accordance with the 144.
Yes, madam.
Lordship.
Just close by that.
Yes, lordship, I'm just concerned about the citing criteria. If citing criteria is fulfilled, if they comply with this, I don't have any problem.
He is happy enough to terminate his license, my lord.
I'm happy, lordship, I am a concerned
We don't
citizen
know.
there.
We don't know.
I am a
But the
concerned
affidavit of the
citizen there.
respondent says so, my lord.
Lordship, I have to argue on this, on another point, Lordship, regarding mentality. But as right now, the needful question is whether the distance regarding distance.
So you see,
So-
we are once again repeating the same thing. Let us assume for the time being that there is a personal interest of the petitioner, correct?
Yes.
So his affidavit would be wrong. But what happens to the public interest vis-a-vis the school? Can any authority come and say that no, the guidelines are not required to be followed? We give Mr. Bhattakur also an opportunity.
Yes.
If they don't want to say, just file an affidavit, end of the matter.
I cannot counsel, my lord.
We dismiss the matter here and particularly in Devini.
Liberty may be
But-
given to me after if the distance is more than 30 meters, Lordship.
You participate in the process when they come. Normally, the deputy commissioner, when they send it for site verification, they give notice. You participate in that
So
process.
144 may be complied with. I don't have any issues. lordship. I don't have any issues.
Yes, Mr. Barua, anything?
No, I am only representing Central Commission Control Board as regards the guidelines. I have been clear in my affidavit. So that part, I have very limited role in playing.
Okay. And Mr. Hazarika?
Lordship, one, some maybe.
Okay. And you are also there, Mr. Hazarika? No. Okay.
আমি ন্যাচারাল জাস্টিস ফলো করার কাগজ সাবমিট ইয়ে কৰিব দিয়া নাই তাক
Mr. A. Kalita, learned senior, learned counsel for the petitioner. Also heard.
Lordship,
Mr. S. Roy, learned CGC appearing for respondent number 1 and 2.
1 and
And Mr. S. Barua, learned standing counsel for the respondent number 3. Mr. S. Bhattakur, learned standing counsel for respondent number 4. You are standing counsel or counsel?
Counsel, my lord.
Learned counsel for respondent number 4. Mr. H.K. Hazarika, learned government advocate appearing for respondent number 5 and 6. And I'm sorry, I forgot the. Huh?
UB Sharma.
Mr. U.B. Sharma, I'm sorry, I forgot. U.B. Sharma, learned counsel for respondent number 7. Next one. by filing this writ petition in form of a PIL, the Petitioners Society has prayed for a direction upon the concerned respondent authorities to restrain the respondent from using the where have you described the land?
Page 140, madam.
No. In the writ petition, you must have said somewhere.
Page none, madam.
Because if the prayer is vague, you'll have to amend it. Because if the prayer is vague, in your prayer you say land. Which land?
We have said, Lordship, that it is adjacent to the school. That's what we have said, Lordship.
No, but once you are annexing a document, you have to give the description of land because then you'll have to amend it. Have this.
Lordship, page 17 we have stated.
Seventeen.
17 we have stated about the school, Lordship. I'll just take a Lordship. Lordship will find at page 18
Yes.
in E, Lordship.
Okay.
E, Lordship.
Okay. For setting up of a retail outlet. What did I say last line? Acha, from using the land covered by DAG number 663, 664, 665, and 666 of Pata number 272, 273, 274, and 275 of Tihu town, which is adjacent to. Now, which school you are referring to?
That's Sarveswar Das Senior Secondary School, Lordship.
Adjacent to Sarveswar Das
Senior Secondary
School, Tihu, for setting up a petroleum retail outlet. Next paragraph. Referring to the documents annexed to this writ petition, to this PIL, the learned counsel for the petitioner has submitted that the requisite setback of the retail outlet from the adjacent school has not been maintained. Full stop. In this regard, the learned counsel for the petitioner has placed reliance on the various clauses of the Which page is that brochure?
Brochure starts from page 50, Lordship. and
50.
50. And the relevant pages are page
Of the brochure regarding selection of dealers for regular and rural retail outlet as published on 24th November 2018. Read with, where is that direction of the solution pollution control board? 126.
Yes, Lordship. 126.
Read with office memorandum dated 7/1/2020 issued by the Central Pollution Control Board. Where is the 30-meter guideline?
That is there at
131. Specifically, comma, the reliance is placed on clause H relating to citing, SITING, citing criteria of retail outlets whereby it is provided that the retail outlet shall not be located within a radial distance of 50 meters within bracket from fill point, public dispensing units, public vent, VENT, pipe, whichever is nearest, bracket closed, from schools. Full stop. The next para, the learned counsel for the petitioner has also submitted that the no objection certificate that was issued by the Deputy Commissioner, Nolwari on 2/06/2020 which is accompanied with a site map is not in accordance with the prescription of section 144 within bracket 2, rule 144 within bracket 7, and the pro forma of no objection, appended to rule 144 within bracket 7. Next para. In support of his submissions, the learned counsel for the petitioner has placed reliance on the decision of the Madras High Court in the case of this one, K.N. Shanmugam. Citation is 2019 SEC Online Madras. I have marked it. Next para. At the outset, the learned standing counsel for the respondent learned counsel for respondent number 4 and the learned counsel for respondent number 7 have raised a preliminary objection with regard to the maintainability of this PIL on the ground that the petitioner has been set up by a nearby retail outlet.
As per the hyperload.
Huh?
Not been drafted as per hyperload. It's not been drafted as per the
Ah.
hyperload.
To stop. Moreover, the PIL has not been drafted in accordance with the Guwahati High Court rules relating to PIL.
Yes, sir.
Post it is also submitted that that as per their instructions, the petitioner is very closely associated with one of the applicants to the huh?
Before setup of our petrol pump in the EU township, there was only one petrol pump. And the petitioner is a private person who has signed. His business partner is a member of the EU number. I have.
No, I did not get it. Please repeat again.
No.
I did not get it.
What he is saying is that the petitioner, who is that represented this organization, he is a friend or partner of one petrol pump which is already existing there.
That's what I was saying.
Yes, see, that's what.
That's what I think. That's what I was
Yeah,
dictating.
I do not agree with this, Lordship.
No, it's
but
okay.
He's saying. Yes.
He is a business partner or oblique associate of the only petroleum retail outlet in Q Town.
That is his allegation.
It's okay. We're not going on that. We are just accepting your. We're just recording your submissions because we are not strictly dismissing it on that ground. So I'm not referring to it. Next para. Without going into the nature of preliminary objection raised as regard maintainability of the PIL on the ground that the drafting is not in terms of the Guwahati High Court rules relating to the PIL. And without entering into the question as to whether the petitioner has been set up by a business rival of the respondent number 7. The court is of the concern, is of the considered opinion that when an issue is raised, that the statutory prescription of the distance from a retail outlet to a school is not maintained. The public interest which is projected to have been violated. No, sorry, no, not the public interest in the issue when the boundary of the retail outlet with the school is not maintained. The element of public interest is found inherent in this, not inherent, existing in this PIL. Accordingly, the said objections raised with regard to maintainability of the writ petition is not accepted. Next para. However, we state here that this, the overlooking of the non-compliance of the Guwahati High Court rules is not has been done under the unique circumstances which exist in the present case, and therefore this would not be a precedent for any other matter.
But that was not raised earlier.
That's okay. Next para. The it would be appropriate to quote the provision of Rule 144 of the Petroleum Rules, 2002. This 144, when you quote, there is a pro forma of no objection. That also, you just see from here. 44.2. This up to note. Just look at this. The heading. 144. It starts from here, next page, and then back up to here. Next paragraph. We also having seen the prescription of Rule 144. We are inclined to quote here with here under the no objection certificate dated 26/2020. This is page 140. After you quote this, then next para would be therefore expressly it appears that the said no objection certificate issued by the Deputy Commissioner on 26/2020 is not in accordance with the pro forma no objection certificate appended to Sub-Rule 7 of Rule 140 of the Petroleum Rules, 2002. Next para. The site map which is appended to the no objection certificate does not bear the counter signature of the Deputy Commissioner. Full stop.
And the official seal also.
Official seal, if his signature is not there, seal will not be there. Full stop. Full stop. In this regard, it would be appropriate to quote the provision of Rule 2 within bracket 10 of the Petroleum Rules, 2020, which prescribes the definition of district authority. Full stop. Therefore, as per the provisions of Rule 144, read with Rule 2 within bracket 10 of the Petroleum Rules, 2002, not only the no objection certificate is to be made in accordance with the prescription of the said rule, but the site map is also required to be countersigned by the Deputy Commissioner, now redesignated as District Commissioner Nagaon. Sorry, not Nagaon, it's Nalbari. Next para. Next para. In this regard, the decision of K.N. Shanmugam within bracket Supra, comma, cited by the learned counsel for the petitioner. Squarely covers the point. Next, but accordingly, without expressing any opinion in the or on the merit of the case, comma, the court is inclined to set aside the no objection certificate dated 26/2020, bearing number page 140, bearing number NA .35/2019/53, issued by the Deputy Commissioner Nalbari, full stop. The court is inclined to remit the matter back to the District Commissioner Nalbari for conducting a fresh inquiry in accordance with Rule 144 of the Petroleum Rules, 2002, full stop. We also grant liberty to the petitioner as well as the respondent number 7 to submit their relevant documents, materials or objections before the District Commissioner, Nalbari, for the purpose of enabling the said authority to make an inquiry full stop. Next para. Suggest a date when you can all appear. No, that is the second part. No, just tell us a date, because we are giving a date so that the Deputy Commissioner, you appear on the same day. We don't want any further delay in the matter. Next part. Accordingly, the petitioner, the
May 21st, Lord sir.
Before that, 8 April. After BU, he will be not there, my lord.
No,
No, we don't know, because you see,
I'm submitting, my lord, because my lord, if he terminate, my lord, he cannot run the petrol pump, my lord.
Yes, Lord sir, before we have vacation, Lord sir.
Before BU vacation, my lord.
As because honorable court have directed to take part in the inquiry, the marriage ceremony of his son is going to be held.
We terminated that before.
And after my.
we'll accommodate that. It is a marriage. We take his word for it. No, okay, we accept your statement on that.
If he terminate, my in the meantime, then my lord, again, my lord, we are in trouble.
Because but there should not be any hindrance in termination.
No, if you do that, then this exercise would not become unnecessary. We are not stopping you from doing anything.
Yes,
We are not restraining you from doing anything. No, we are not saying anything. Neither we are observing, not we are allowing you, not restraining you. It's a separate, which is not the subject matter of this PIL. Make it 29th Monday. You get sufficient time.
29th, yes.
29th for with all the concerned parties, including the BPCL, can appear before the Office of the Deputy Commissioner, District Commissioner Nalbari, on 29/4/2025, and by producing a certified copy of this order, wait for further instructions from the said London authority. Full stop. It is expected that the said authority shall conclude the inquiry within a period of 1 month from the date of appearance of the parties before this authority. Full stop. It is provided that once such inquiry is conducted, probably completed, the District Commissioner Nalbari shall pass a speaking order and communicate the same to the parties. Next paragraph. This PL stands allowed to the extent as indicated above. Next paragraph. There shall be no order as to cost.
So not no requirement to issue a face NOC madam if required.
We'll pass a speaking order, we'll complete everything.
Obliged, much obliged.
Thinking about the subsequent mistakes, madam.
Huh?
I'm thinking about the subsequent mistakes, madam. After him, yes.
Highly obliged.
My lord, item, fourth item 4, my lord, it was a part-heard matter. May I pay for listing of the matter in the, on 3rd April or 8th April, my lord, any day of the 3rd April or 8th April. If possible, my lord. Maybe.
3rd April or
8th April, my lord.
8th April. It's very close to, make it 3rd April.
My lord.
Which item? Item number?
Item 4, my lord.
For your positive time matter could not be taken up today. List on.
My lord. Deep lovely.
Let it come after view.
My lord. It was part-heard matter, therefore.
No, we understand, but there will be a disruption in the bench. This
My
1 or 2 days is
My
really, you're not being able to
After-
manage. Tell us a date when, after view.
My lord, after Bihu, my lord, I have no objection, my lord, any date, my lord. 22nd
Oh, what was the issue involved here?
My lord, review matter.
Okay.
Only, I am to make a just reply submission.
Okay. Make it 23rd April.
My lord. 23rd will be, my lord, Wednesday motion day.
Written motion day. We'll take it up on that day.
It's hearing matter, my lord.
You said that it will take only a short time.
My lord.
So
My lord.
we'll try to manage. Because this, due to disruption of the bench, there are few parted matters and the special bench
Yes,
in
my lord.
between.
Yes,
So we are not being able to know with certainty what will be taken up on that day.
my lord, my lord.
That's why. But these APSC matters are also, again, they will also come. These special 2 benches are there. So there's some disruption.
My lord.
Heavy. They like